Hello, everyone. Today is Thursday, October the 19th, 2023. Welcome to PACO's Workers' Compensation Roundtable. Joining me today is Ken Finley. Ken is with V&A Risk Services. He has 30 years experience assisting companies with unemployment and workers' comp issues in Ohio. He serves as a resource for clients who have questions on their workers' comp account or need to know the impact a claim may have on their bottom line. He guides customers to the steps they need to take to reduce the impact and deliver the best outcome. He also represents V&A at as many networking functions as he can manage, and that is where I met Ken at a recent networking event. And Ken, welcome. Thank you so much for joining us today and sharing your expertise with us.
Thank you. Happy to be here.
I will turn it over to you.
Okay. I will share PowerPoint. Let me know if you have any issues or any questions throughout. I know Angela's going to be checking the chat room, so if you have anything, please let me know, because this is for you guys. I know this stuff already, and I can put you to sleep with it, but I don't intend to. So it's just workers' comp. So, all right. So let's talk about taking the horror out of Ohio workers' compensation. Timely, right? Because we're in October. All right. So the four things that I wanted to go over today would be the Ohio workers' comp, how it's set up, how you can go on this haunted hayride. The second part would be how a claim would haunt your premium rates. And then steps to outrun a zombie claim. And then if you're in the escape room, how to get out of it with discounts and rebate programs. So hopefully that sounds like fun. So I know that there's probably a wide range of experience with workers' comp. So I'm going to speak specifically about Ohio and how it's set up, because that's where the only state I operate in, because it's so weird. Ohio is different than all but 3 other states. So we are monopolistic. You cannot buy a private insurance policy for workers' comp in Ohio. You have to buy it through the state. So the Bureau of Workers' Comp it's a monopolistic state. So the BWC is in business to operate the workers' comp system for Ohio. But I will say that they, back in the early 90s, were at some points taking up to 600 days to pay providers. So the state legislature said that wasn't good enough, which you would probably agree with. And so they required them to privatize the part of bill paying and intake of claims. And so there are organizations called managed care organizations, MCOs. There are only, I believe, 9 of them left. There were 58 to begin with in the mid-90s. So they've all kind of bought and sold each other. And so there are only 9 existing MCOs. And so every employer has one assigned to them, or they picked one. And so they are in charge of paying the bills and following the treatment plans or developing treatment plans. So that's the MCO's role, to intake the claim. So there also is the Industrial Commission, and the Industrial Commission is in place. It's the adjudicating arm of the Bureau of Workers' Comp. So they're not related structurally, but every incident or everything that is appealed on the workers' comp side goes to a hearing before the Industrial Commission. So that is their role, and so they're independent of the BWC. But speaking of independent, there are third-party administrators, which is what my company is, V&A Risk Services. So we represent employers. We are recognized on the Bureau's website as a service provider for our 12, let's see, we have 2,500 clients now. So for those companies, we're listed as their TPA, and we can actively help them with their program or help them with their claims as well. And then, of course, attorneys, which you guys are near and dear to your hearts, and they represent either employers or claimants, or some of them actually represent both sides of the table at hearings. Not on the same hearing, I would hope, but there are some that represent claimants as well as employers in the different venues that they would have hearings. And then finally, there are the providers, obviously, who are caring for the injured workers. And then there are ancillary services, you know, the independent medical exams, functional capacity evaluations. Those we're going to talk about a little bit more in depth a little bit later in the program. So that's kind of the bottom line. That's kind of the basis for how the system is set up. A lot of people with their hands in the cookie jar, and a lot of people that have interest in getting people back to work safely. So how does this all begin? It all begins with an application for coverage. So when an employer comes into the state of Ohio or starts up a business here, then they apply for coverage, you know, filling out what their job description will be, you know, how many installments they want to make, estimate their payroll. And then the Bureau of Work, or I'm sorry, the state of Ohio is nice enough to give them, brand new employers get a 25% discount up front, called Grow Ohio. So our governor, DeWine, put that in place to reward companies that are coming. Actually, I think it was Governor Kasich that put that in place initially. And so everyone that comes in that's brand new, starting a new business, thank you, you get 25% off. They do have the opportunity, if they're a new business, if they qualify for the Grow Ohio 25% discount, they can instead get into the group rating programs, which we'll talk about in a bit. And those are getting a 53% discount off of the rates. So that's a much better deal depending on the size of the company. And so we are able to put them into our group, and they do that through a TPA. So you don't have to have a TPA if you're not in a group program. But of course, I recommend that. So, all right. So if you're applying for coverage, then this is, now that you've got coverage, how are your rates determined? So for companies that have been up and running, the Bureau of Workers' Comp takes a snapshot of their account on September 30th of each year. So it just happened a couple weeks ago, and it set the rates for policy year 2024. And when we say policy year 2024, we're talking about July 1st, 24 through June 30th, 25. That is the state's fiscal year. And so that is the policy year for the Bureau of Workers' Comp. So at that snapshot, the Bureau looks at a 4-year window of experience to determine the rates for that employer. So they're going to look at, so they did look at claims and payroll between the dates of July 1st of 2018 through June 30th of 2022. 18, 19, 20, 21. I always have to pull my fingers out and make sure that I've got a 4-year window there. So what happens is, for every dollar of payroll, depending on what manual classification it's in, whether it's a construction code or whether it's in manufacturing or transportation or even clerical, there is an amount of expected losses that you get credit for based on your payroll history. So even a small law firm that, you know, you don't have a lot of expected losses, you may have some paper cuts. There is an expected amount of losses. And if you're doing better than expected, you can expect to get a credit, a discount off of the Bureau's average rates, the base rates. Or if you have more in claim costs than you're expected to, you can expect to pay a penalty above the base rates. So let's talk about a claim. So when we're looking at this snapshot of a claim, here's what happens. Initially, when a claim occurs, the Bureau of Workers' Comp creates two buckets, one bucket for medical and one bucket for indemnity compensation. So what happens is initially a claim happens, they anticipate that this person's going to be off work for some time. And based on past history, the Bureau then puts a medical reserve and indemnity reserve on the claim. And as in theory, as costs are then paid out in the claim, it comes out of that bucket and into the other column, which would be medical paid or indemnity paid. So the idea behind the whole concept is to keep the cost of the claim level during the time that it's in the experience and active. So the medical and the reserve, or the medical reserve and the indemnity reserve, those amounts will go to zero temporarily if a claim goes 6 months with no activity. So if they stop treating and they go 6 months, it doesn't make the claim inactive until there's been a year. But if it has been 6 months, the Bureau will change that reserve to zero. And so the employer, basically reserve can be looked at as a rate making tool. It's the way that the Bureau of Workers' Comp can charge that employer more for the 4 years that the claim is in their experience, so that they can continue to pay any benefits after it's out of experience. So you can understand that the employer is going to pay higher rates while that claim is in there, so that the Bureau can build up the state fund and pay out. And of course, we're not talking self-insurance when we're talking about this snapshot and the components of a claim. It's a whole different ballgame for self-insurance. We'll talk about that in a bit. So look at me just leaving these seeds down so that we can go back down leaving the breadcrumbs, right? All right. We try and have fun in workers' comp. So what happens is the experience modifier then determines what percentage of the base rates an employer pays. If they have a higher experience modifier, it means that they've got more claims than expected. And so then they pay a higher percentage of the base rates they pay on top of it, and a lower EM. So a lot of times when construction jobs are being bid out, they like to see an experience modifier of less than 1.00, because that means you're doing better than you're expected to. So, all right. And of course, any questions on this, please let me know. Okay. So then what happens annually is the Bureau reports to the employers what their estimated annual premium is for the year. And every employer will get that in the mail to them, sent before May 1st. And it's going to tell them what the Bureau expects them to pay in premium this next year. It typically will use the actual payroll from the last trued up year. So for the July 1 of 2023, policy year 23, they're using old payroll from 2021. Why? Because that was the most recently made available history that they had to go off of. Policy year 2022 was still in process by May 1st. It hadn't been completed yet. So the Bureau oftentimes will be using very old payroll data to set premiums for the next year. So they'll use the current rates, the policy year 2023 rates, whether they're individually rated or in a group. And like I said, we'll talk on programs down the road here. And they figure out what the frequency of installments are. So employers, this may be minutia to you guys, but employers can change how often they are billed by the Bureau. Right now, when they set it up back in 2015, everyone defaulted to paying every 2 months, which to me is very confusing, but a lot of employers are still on that schedule. So they can change to monthly, quarterly, annually, whatever they want to do. So they can make that change when they get that installment schedule, but the first installment that they have to pay is always due June 21st. So every employer, state fund employer in the state is going to pay a bill to the Bureau by June 21st. And I'm talking about private employers. It's a little bit different for public employers. They're on an annual. So I don't have notes about that in here, but just know that I'm talking about private state employers, state fund employers. And if they do pay off their entire annual premium by June 30th, they'll get a 2% rebate off of that.
And I have a question.
Yes.
If your rating is based on your payroll from 2 years ago, essentially, and in that time, you've had a restructuring of your business, or for whatever reason, you have, say, half as many employees. And so your current payroll and your current number of employees is drastically different than it was 2 years ago. Is there a way to appeal and have your rates reset, or is it just a matter of you just got to wait and it'll even out in the end?
Okay, so the rates are set. Those won't be changed, but the amount of payroll that they use to calculate your premium can be very easily. So if they're estimating that you're going to have $1 million of payroll in your manufacturing code, and you are a third of what you were, or you're anticipating a third of the payroll that you had back in 2021, you can ask them to adjust that. Especially you want to do it before May 15th. So you have a little bit of a window there, but you can always update that even after you've made the first installment. The Bureau will adjust that for you. So if you say, no, we're going to have about $320,000 of payroll, not this $1 million. If you call your employer service specialist or have your TPA do it, I did that for a lot of our clients, then we just have to submit it to them and they will recalculate it for you, and your premium, the premium difference will then be spread over your remaining installments. So if you do it before the first installment is due, or actually before the first installment is billed, technically, then it will spread over, all of your installments, whether you're monthly or what have you. If you do it after that first billing, then the future installments will be adjusted.
Okay, thank you.
Okay, yeah, great question. All right, so there's Wednesday. I am excited about season 2, but I understand it might not come till 2025 now, so. All right. So outrunning a zombie claim. So let's talk about some ideas that you can instantly use to save on the claim costs. So first and foremost, one big savings that we see for cost wise is if the injured worker will go to urgent care rather than the emergency room. Now, obviously, there are definitely cases they should go to an emergency room. But if it's something that, happened a day or two ago and they just need to be checked out, there are definitely urgent care facilities or Ahmed clinics that will do a much more cost-effective job for your injured worker than the ER would. And there's quite a bit of savings in doing it that way. So just something to keep in mind. And these are just ideas that that have come across over the years. So these are things you don't have to do, but just some things that we know will help keep the cost down. Employers can enroll in the $15,000 medical only program. And in that program, if they have a medical only claim, then the bills would go directly to the employer, and the employer would pay those bills, keeping those costs out of the workers' comp experience. So when the Bureau takes a snapshot of a claim, if you as the employer have paid, $10,000 of medical out of pocket, then you'll have no costs on your snapshot. so you'll get better rates. Your experience modifier will be better, so there are advantages to that. And going back to so you have to have that in place before the claim happens, though. If an injured worker, is going to be off work, can we get them back to work in a light duty assignment? Is there something within their restrictions that we can do to bring them back and get them back in the workforce and get them back to working again and helping the company, but also safely? I mean, that's the key, is you're not going to bring somebody back that you can't put on a duty within their assignment or within the restrictions. And then if you have an employment issue, then you definitely want to get an attorney involved at the onset of the claim. If especially when you're talking about things like presumptive, whether the claim is going to be allowed or not, and whether there's a drug screen so there are definitely reasons that our claims managers would recommend that an employer talk to the attorney. I mean, we represent employers, so I'm speaking from that perspective. So there are often times that we would, suggest that they get the attorney involved at the onset of the claim. So that might be good news for you guys.
And just,
yeah.
I'm sorry, just to clarify one point for those who don't have a lot of workers' comp experience, the difference between when Ken was talking about a medical only claim, that is a claim where the injured worker doesn't lose any time from work. They're not going to receive any compensation, any temporary total or wage loss or anything like that. And those claims can be treated a little differently than an injury where there's lost time and you're going to be paying compensation as well.
Perfect segue. So yeah, if it's more than 7 calendar days from work, it's considered a lost time claim. So anything less than 7 calendar days off work, or 7 or less, is considered a medical only claim until there's a permanent partial award paid or some compensation. So the question is, for employers, I'm educating them all the time as to how their injured worker is compensated. If the injured worker is off less than 8 calendar days, then there's going to be no temporary total paid, as Angela was saying. But if the injured worker is off for 8 to 14 calendar days, they're going to receive temporary total compensation for those days 8 through 14 only. If it is such that a claimant is off more than 14 days, then they will be eligible to receive temporary total back to day 1. So that first week is only payable if you've been off for 2 weeks. And the temporary total will continue until maximum medical improvement has been reached or some other events that might take place in a claim. All right, so employers ask me all the time if they should continue wages. So the things that will benefit the employer here would be, well, first of all, the employee would, if they do continue their wages, they have to continue the full wages and benefits to the injured worker. They must not miss a paycheck. There is a form that they can submit to the Bureau of Workers' Comp called a C-55, which was just declared a couple months ago to be optional. So you definitely want to at least keep good records, and we would recommend actually sending payroll history to the Bureau to put into the claim records so that they know that that injured worker was paid for their time off and that the Bureau should not be cutting them a check for temporary total. And of course, anything that the employer is paying in compensation would not be charged to the employer in the snapshot, would not be part of the workers' comp claim. The medical costs, obviously, and the reserves would still be part of the claim. The employer can terminate salary continuation if the injured worker, if the claim is going on longer than they anticipated. If things are not, that, hey, we weren't expecting him to be off 3 months, we were expecting him to be off for, 2 weeks or something like that. then obviously things have changed, and you can ask the Bureau to begin paying temporary total at that time, or we can, your TPA can. And on average, the Bureau of Workers' Comp does collect between $2.50 and $4.20 for every dollar they pay out in benefits. So that's a staggering number, and something that employers should be looking at. What are ways we can keep our costs down in our claims? And that's one way. And it also creates goodwill for the employee. They know that they're going to be taken care of. They don't have to wait for the Bureau to make the payment, and send them a check for temporary total, or post it into their, into a card or what have you. And also, one other point is that the temporary total that they would receive would be 72% of their wage that they would have earned the past week before their injury, or the average of 6 weeks with overtime before their injury. So they're only going to get 72% of what their payroll was. However, it's tax-free. So hopefully it's, kind of offset. But obviously, if you're paying their salary continuation, they're going to get their full wages and benefits. And that, of course, will be, you've got all the costs that come out of that. So it might be a wash, but just letting them know that, if you're doing salary continuation, it takes some of the fear out of it for them. Okay. And then, would an independent medical exam be appropriate? Hang on just a second. Okay. So would an independent medical exam be appropriate in a claim? So there are different reasons that you might have an independent medical exam done. And this would be scheduled by either the TPA or the attorney, or whoever is, working on the claim for the employer. If you're disputing the diagnosed conditions, or if you're checking the extent of disability, if there's a request for permanent total disability, additional allowances, there are all kinds of issues that you might seek an independent medical exam. And by the way, we're going to make these slides available to you after. I should have told you that at the beginning. So don't feel like you have to write all this stuff down. You'll be getting it. You can, she'll send it out, I believe, right? Angie, you'll be sending that out. Okay. So the employer, the appeal for the employer on permanent partial awards or medical issues, those are all reasons that you might schedule an independent medical exam. Of course, the costs come out of the employer's pocket. And so you would inform the injured worker of the time and place via letter, and give them at least 2 weeks notice. These are notes that my claims managers have put in here, so I trust that they're accurate. And then you also do have to file a copy in the claim file and copy the injured worker's attorney, so that they're aware of everything that goes on with the independent or the IME. And then in some cases you can do a medical review, a physician's review. And that would not involve a review by an in-person review of the claimant. That one could be done just by having them review the actual claim and the medical in the claim. And so that is it's a less costly exposure, and it also, if that comes back, it does not have to be filed in the claim itself. An independent medical exam does need to be filed with the Bureau. A physician's medical review is something that you can do to learn what the reality is of the claim, and whether it's appropriate or not. And as I said, the employer pays the cost of the exam or the review directly. Okay. So here are some other programs and other things that can help reduce costs. Transitional work you can have an expert set up the program, and then they would do some job analyses. So they would review the different functions that your employees are doing and determine how much of the, how much sitting, how much standing, how much weight they're lifting. Those are things that you can have you can have that information on hand. And it especially helps to communicate with the treating physician to say, well, we have this position available. Would the injured worker be able to perform these duties? Would this be within his restrictions? Is this something we could bring him back on light duty with? And so it helps to defray the cost. There are transitional work grants that will help defray the cost of implementing the program, of the job analyses, and annually, and we'll talk about this in a bit when we talk about the different programs, you could get up to a 10% rebate of your premium if you've got a transitional work program in place and you enroll in the Bureau's transitional work bonus program, and some of your employees do use that program. All right, and then another topic that will help reduce costs is subrogation, and you guys are probably familiar with some of these claims. So this is when an injury is caused by a third party, and the Bureau of Workers' Comp does have the right to subrogate the costs if the injured worker has collected from a third party. So in this situation, it's the Bureau's legal department pursuing reimbursement of medical or compensation that they paid out, and it would reduce what the injured worker would get from the third party insurance, because those are costs that they already had received or had already had covered by the Bureau of Workers' Comp. And then the reduction of, so any subrogation that they do receive at the Bureau would then be applied to the employer's experience, including future snapshots, but also going back, if this claim has already had an impact on your rates, they'll go back and recalculate the rates for those years that it was in there and give a reimbursement for premiums that have been overpaid. And then there's something called not at fault motor vehicle accidents. So if there's a form called an AC-28 that we would complete for our clients. This just began July 1st, 2017, which sounds like not that long ago, but my goodness, that was a long time ago already. So effective July 1 of 2017, the injured worker, if they were on the job and there was a claim filed and a third party was at fault for the motor vehicle accident, then the employer can file an AC-28 form with the traffic crash report, the police report, and the letter of acceptance of the claim by the in effect assurance at the time of the accident. If they submit that information in the AC-28 to the Bureau, then the Bureau will never charge their account for any of the costs in the claim. They would be charged to the surplus. So the important thing to note here is that this is not dependent upon whether the injured worker gets benefits from or sues the third party's insurance or gets any kind of benefit from them. This just means that any costs that might come up in that claim would not be charged to the employer. Instead, they would be charged to the surplus. Part of the beauty of this is that once that happens, anything that happens in the claim, you just want it to be for the benefit of your injured worker. They obviously didn't ask to be in a motor vehicle accident. They were there because they were on the job. And if that was the case and it was a third party's fault, then you want them to get the best care they can. And if this AC-28 is in place, then all the costs are charged to the surplus, and you just want your injured worker to be taken care of. So we like this program. Any questions on any of this stuff? I haven't seen anything come in the chat or anything. Okay, we'll keep motoring on. So let's talk about handicap reimbursements. So the Bureau of Workers' Comp does allow some reimbursement to the employer if there was a pre-existing condition that pre-existed the injury. The most common we see are arthritis and diabetes. Arthritis by far is the most prolific one, but there's also diabetes, epilepsy, 23 other conditions that if one of those conditions was in existence prior to the injury, then it may slow down the recovery time, and the employer may be entitled to a percentage discount off of the claim. It has to be a lost time claim with temporary total or salary continuation paid. So if it's a permanent partial award, like a pain and suffering award that was paid, and that's the only thing paid in the claim, we can't get a handicap reimbursement on that. But if it was a lost time claim, then with temporary total or salary continuation, we're able to do that. So the Bureau may grant a discount to the employer. We obviously have to show them where in the medical documents, especially surgical notes or what have you, that this condition pre-existed the injury. And so those appeals then go before the Industrial Commission if we want a higher percentage, but we usually just take whatever the Bureau, we give them a good enough documentation that the last batch of them that we did a month or two ago, we were seeing 30 and 40 and even 50% handicap reimbursement for the employer, which is really a good benefit. So the Bureau, just like with subrogation we talked about, they will go back and adjust the rates and make them clear, make any adjustments that should have happened back when the claim first happened in their experience. And so they'll get an adjustment of their premium for that time. And the important thing to know here is the injured workers' benefits are not affected by any of this. They are still going to be able to collect any medical, get any treatment, and get any compensation that they deserve within the claim. It's just that it's going to be discounted when it's charged to the employer. So the injured worker, in fact, doesn't even know they're pursuing a handicap reimbursement. So, okay. And then there are settlements. So essentially, the injured worker could take a settlement to cover the cost of their future treatment or lost wages. It's negotiated between the injured worker's attorney and the employer's rep, either the TPA or the attorney. I would say probably 80% of these are done by the attorney and very few are done by us. And we'll talk about that for a bit about court of common pleas and that kind of fun stuff. So once the settlement amount is agreed upon, then a C-240 application for settlement is completed by both parties, sent to the Bureau for approval, and the Bureau then notifies the MCO notifies all the providers in the claim to get their bills in, and then the Bureau of Workers' Comp will cut the check. And the amount of the compensation or amount of the settlement is then added to the compensation indemnity paid in the claim, but the reserve goes to zero. So that's how it impacts the rates for the employer. And it considers the claim done. So any future medical that the injured worker may request would go through. They would have to do it on their private insurance, unless private insurance discovered that it was because of a workers' comp claim. And then they would obviously tell them, no, we're not covering this. You would have to take it out of your settlement. So that's the idea behind it. So some notes that I would put in here about settlements is that I would be open to settlement if it's a former employee and it has an open reserve, or if it's to save court costs. So if a claim if the claim has already gone through all three levels of the Industrial Commission, which would be the DHO, the SHO, and then the full commission, if it's made it through all of those three and it's taken to the Court of Common Pleas, at that point, probably 90%, if not more, of the claims are settled before they ever get to trial. I'm sure it's way more than 90% actually. So there are times when you would want to settle these cases. It does, save on attorney costs and all that fun stuff that you guys, would bill for. And my role then is, if it goes to court, I cannot represent the employer, obviously. We will have an attorney will contact me and ask, hey, what is the impact of a settlement at each of these different levels? And they'll usually give me some settlement levels that they think this claim might get settled at. And I can run numbers forecasting into the future as the geek that I am. And I can run way deep into the future and see, okay, in 2020, in fact, I'm running some out to 2027 right now to determine how much premium they would save if we settled at this point. So that's the role that I play for the attorneys. And I think they usually appreciate that. Because it gives them the knowledge of the impact of the settlement on the premiums and where the sweet spot is. So there's usually a spot where, hey, if we settle it for under this, then it's not going to really impact the employer much. There is a point at which it might remove them from group rating. And if that happens, then the costs go up. So, all right. We have made it to the escape room. So this is where we'll talk about different programs, and I only have a couple more slides, 5 more slides, so you can relax. We'll be done soon. So the question is, is a company large enough to self-insure? So we already mentioned that you have to buy your insurance through the state. And that's still true. You still have to follow the same rules. But if you are large enough to go self-insured and the Bureau grants you that privilege, then you are, or through your TPA usually, are paying the medical and the compensation in your claims. You're also, if there are any disputes, whether a claim should be allowed or not, or if compensation should be paid, those disputes do still go to the Industrial Commission. And you are expected to hold reasonable reserves on your claims. So if there is an active claim, you might set a reserve on that claim of the next 3 months. How much do we expect to pay out in medical in the next 3 months? That might be a reasonable reserve. Whereas the Bureau is looking at lifetime, what might we pay out in this claim? So there's a huge advantage to self-insured companies in this state. It used to be published that you needed to have 500 or more employees. Really 300 is a good earmark these days. If you've got less than that, but you've got the financial wherewithal and strength to go self-insured, we can apply for cover. We can apply for that. We can complete the application and see if the Bureau will grant the self-insurance. One of the biggest costs, of course, is the stop-loss insurance. So typically there's a $350,000 is the typical threshold right now. So you could, in your first year, have a bad claim that ends up costing you $350,000. And as long as your premiums are way more than that, then you have done, then you've saved some premium. So we did have a client that had actually a death claim their first year of self-insurance, which sounds completely horrendous, but they still saved over $1 million in premium. Big manufacturer, auto part manufacturer. So so self-insurance is usually a better deal than state fund. However, state fund premiums are on the decline. They're not as high as they once were because the Bureau is trying to be friendlier to attract business. And so self-insurance is there, but it's, most companies that are going to go self-insured already are. And I will mention with that stop-loss insurance, this is an interesting fact that in Ohio, there's no aggregate stop-loss insurance. It's only offered on a per claim basis. So you might have, 5 claims in 1 year and they could all hit that $350,000 threshold. So there is some risk involved in that. Okay, so if you are in the state fund, the promised land is group experience rating. Because if you have a good enough experience, then when we take that snapshot, then when the Bureau takes a snapshot, then you could be put into a group to getting an upfront discount off of your BWC premiums. So again, like I said, less in claims cost than expected. You would pay the group rates rather than your own rates. So it's just like health insurance, where the bigger the company is, or the bigger the group is, the less they need to pay, because they can spread the risk over more companies. So we have to file that roster the Monday before Thanksgiving. So actually 1 month from tomorrow. So that we have to file that every year for the next July 1st. We file our rosters. There's a program called Group Retrospective Rating. And in that, the employers pay their individual premiums. But then if our group does well, claims management wise, then they can receive rebates in a couple of years. 1 year after the claim year ends, they can receive rebates off their premiums. Sometimes that can be a bigger rebate than they would have gotten if they were in group. But there is risk involved, because if the group has a bad claim year, then employers could pay assessments additional above the premium they've already paid. So it all depends on what claims happen and what factors the Bureau uses to calculate that stuff. We've never had a group have to pay any assessments, and the rebates typically have run around 40% on average for each of our industry groups. We have had some lately that are in the 20s because the Bureau's made some changes to the factors, and they are kind of disappointed that not enough companies are paying assessments. So call it what it is. So there's more risk in the retrospective rating program. There's no risk really in the experience program. There's also the drug-free safety program, which employers can enroll into, and they can get a 4% rebate if they do all these things. They have to do pre-hire, post-accident, reasonable suspicion testing. Also 2-hour supervisor drug-free training, 1 hour for every employee drug-free training every year. And then you can bump up to the advanced level if you do, and get 7% if you do all the above, plus have an action plan that you file online, do random testing of at least 15% of your employees, or be part of a consortium that will pick 15% of the population. In that regard, they want you to have a second chance agreement, so they frown on one strike and you're out type of programs or policies. So they would ask you to try and rehabilitate. And so that you would have to have an EAP available to them. And there's also the comparable level, which is for state contractors. It does not come with a rebate, but some are required. If you're working with the state, you have to be in the drug-free safety program. All right, fun stuff. We've already talked about transitional work bonus program, so this will be short and sweet. You have to have the program in place. The job analyses we talked about, it identifies light duty jobs. Here's where I was saying, if you have one claimant that uses your transitional work program to come back to work that year, you get a 10% rebate. If you have two claimants that have that opportunity and they both do, you get a 10% rebate. However, if you have two claimants that could use it, but only one does, then you get a 5% rebate. And if you don't have anybody that has a claim that year that could use a transitional work program, or nobody uses it, you get a 0% rebate. So it's not, if you have the program in place, you don't automatically get 10%. But if it does bring somebody back through that program, then you do get the benefit that year. There is something called the Safety Council Rebate Program. If you are a member of a local safety council like this, we've got Safety Council of Northwest Ohio up here. If you attend, you have to attend 10 Safety Council events during the year. And the Safety Congress that they hold down there in Columbus does count for one of those events. If you do that, you get. I see this note in here about the CEO officer. I don't know if they enforce that anymore. I haven't seen that on the documentation, so it's probably a note that I just have failed to take out of there. But anyway, we're you know, that's minor point. But you do get a 3% rebate of your part of your premium if you attend the 10 meetings as a member of the Safety Council during that year. And that, my friends, is the end of my presentation of workers' comp in Ohio and the horrors that it could be, but how you can avoid the horrors. So, please, any questions you have or anything else I can elaborate on or didn't even touch on, I'd love to.
I do have a question.
Okay.
Can you speak briefly about when a claim hits max value? I know there are a lot of times that
Yes.
we will have we'll be working on a claim with an employer, and at the claim reaches max value, and the employer decides, okay, we're not going to continue paying legal fees for this claim because it's not affecting us anymore.
That is a fantastic question. I wish I'd addressed that in there. Yes, a claim hits max value. It depends on the amount of expected losses that the company has over a 4-year window. That determines what their max value is. It can be anywhere from $2,000 to 4 to 6 to 8. It goes up to 25,000 to 250,000 as the top. Okay, so it does matter to the employer when a claim hits that amount in payouts. So I look at a claim and I say, if there's already been compensation and medical paid out that exceeds the max value, then there is no further benefit to them financially for spending money to try and beat that claim, unless they can get the whole thing thrown out. You know, that's a little different. But if it's an additional allowance and the claim's already been allowed for, you know, L4, L5, something like that, and it's already hit their max value, and now the person's going for additional allowances, if the claim has already hit max value, that's the most that's going to be charged on their experience on that snapshot. And so anything else that gets paid after that doesn't have any further impact on them. So yeah, max value is a very important concept, and it changes. So an employer, we talked about an employer that might have, you know, be on the downslope from you know, in payroll. Eventually, when those years of payroll hit their experience, they might actually have a drop in their max value. A new employer might be on the rise and might have an increase in their max value. So it depends year to year. So when I'm doing this forecasting, I'm using payroll estimates and I'm, you know, forecasting forward to see what it might be at the end of the claim. So that's a great question.
Okay. Does anybody else have any questions? No? Okay, well then we will go ahead and wrap this up. We again want to thank Ken for joining us today and sharing his time and his expertise. We want to thank Spectrum Reporting for providing the Zoom link and recording today's session. The session will be posted on PACO's website in a couple of weeks, 2-3 weeks. And then if you have something that you want to go back and review the program, you certainly can. That is about all that I have. Thank you all for joining us today and for your time and attention. And we appreciate this. I don't have a topic or a speaker lined up for next month, but I have some good ideas on topics, and Heather and I will be working together to solidify some of these topics and find speakers to come join us next month and then in the months coming. So everybody have a great day, and we'll see you soon. Thanks so much.